Welcome everyone to this session on student disabilities in higher education. I'm Kris Robbetts. I'm a partner in the regulatory compliance team at VWV, where I specialise in education law, and I spend quite a large proportion of my time advising higher education institutions on a wide range of student and regulatory matters. I'm joined by my colleague Brad Evans, a solicitor in the team who's worked with me on a number of student disability matters recently. Student disabilities has been a challenging issue for HE institutions for many years, and even before the pandemic, it had a high profile, generating extensive debate around topics such as funding and inclusivity. And now that the worst of the pandemic seems to be over, such matters remain important, and the time has come for the sector to think again about the ways in which it discharges its legal obligations to the disabled student population. We're going to speak on this topic for 35 minutes or so, and we're planning to take a pretty informal approach. We're going to adopt a Q&A type format, which should leave us with some time at the end for any questions that you may have. So what do we want to cover? Well, in part one, Brad will be quizzing me on a number of topics, including why disabilities remain a recurring challenge within HE, why it's so difficult to manage, complicated, the basis of the legal and regulatory obligations that higher education institutions have. Think about sector regulation and some key sector guidance. Think about the enhanced vulnerability that disabled students experience and some of the lessons that we can learn from the pandemic. And I'll finish up just by considering some recent developments and what we can expect over the next few months. In part two, it will be my turn to quiz Brad on the risks and remedies within this area, what we can learn from the Office of the Independent Adjudicator and the various resources that they publish from time to time, how discrimination complaints should be approached by universities as a general issue, and we'll think in particular about the ways in which the pandemic has had an effect on accepted wisdom in this field. So Brad, it's now your opportunity to ask me a few questions. We obviously know the broad areas we want to cover, so this is not exactly unscripted, but I will now hand over to you.
Thank you very much, Kris. So I think it'd probably be useful to start with the background. And in your experience, why is disability discrimination such an important issue in the sector?
I think there are a wide range of reasons for this. It is a growing issue as the number of students entering higher education with a known disability is on the rise. There are more students entering the market, and more of those students are disclosing conditions that may amount to disabilities. By 2020, 17.3% of all home students have disclosed some form of disability, and that was split broadly between specific learning conditions such as dyslexia, ADHD, and mental health conditions. And mental health conditions like depression and anxiety have gone up a massive 184% in the last 5 years alone. So that in itself tells you quite a lot of what you need to know about how disabilities and the way they're managed is changing. This does affect every aspect of the student experience. It invokes the public sector equality duty that all higher education institutions that are publicly funded are subject to. It's an issue that is scrutinised by various sector agencies, so thinking in particular of the OFS and the OIA, and it does lead to a disproportionately high number of disputes, complaints, claims from disabled students. It also, I think, for me, goes to the heart of what universities are for in terms of their sort of broader societal function in providing opportunities for all. And it's important to note that disabled people are still underrepresented in higher education and do generally still have worse outcomes. So there's always more work to be done.
I hope you don't mind me saying, Kris, but none of this is particularly new. Are you able just to explore a little bit further why these issues are so difficult to address?
I think the complexity can be explained to a great degree by the fact that it's such a pervasive issue, creating challenges from admission to graduation and even beyond there. So it impacts on all processes throughout the student life cycle. It triggers proactive duties on the part of institutions, and it can be dependent on input from third parties such as needs assessors. So there's complexity, there are things that you can't control unilaterally. It can also trigger lots of other procedures, such as fitness to study, which is complicated and a challenge in its own right, and that in itself can lead to disputes. And there are a lot of constraints, and I've tried to list some of those in red text in the slide, factors which affect university decision making and can be challenging in themselves. So the need to protect academic integrity and competence standards remains an issue. The lack of and difficulties in accessing funding is always a challenge. The impact that actually awarding concessions can have on other students, other members of the academic community, and the clear link between needs and disabilities and welfare more generally. All of this means it's a complicated and interconnected issue, and that's what makes it so difficult to address, and it's why it's something that you can't realistically expect to resolve. You can only try and mitigate its effects.
Okay, and on what basis, Kris, would you say that HE providers are required to manage these complexities? Is there almost a checklist where the obligations of HE providers come from?
Well, I'm not sure there's a checklist, but on the next slide, we can see how it's possible to simply distinguish between the sources of legal and regulatory obligations. So if we think about duty of care, which is assumed as a consequence of the relationship between higher education providers and their students. When delivering educational services, they have to do that to a standard of care that will be expected of a reasonably competent institution. Dealing with adults, yes, but adults who for various reasons such as disabilities may be technically vulnerable. There's also the contractual relationship, what's been agreed with students who've elected to study at a particular institution in exchange for fees, and what's specified under the core terms and conditions and any associated policies and procedures. And then you've got those statutory obligations, so imposed by primary and secondary legislation, which do impact on the relationship between the parties. Obvious statutes to mention would be obviously the Equality Act, which recognises disabilities as a protected characteristic and creates the proactive duty to address them. But also the Consumer Rights Act, which affect how universities as businesses are expected to treat students as consumers in order to address that inherent imbalance of power between them.
Okay, and earlier you mentioned sector agencies and regulators. Are you able to expand on this a little bit further and perhaps look at their published guidance?
Yeah, so on the next slide, I've just selected a small number of examples. There's obvious guidance that's been around for years by organisations like the Equality and Human Rights Commission, by Advance HE, which was previously the Equality Challenge Unit. None of that's new, which is not surprising considering the Equality Act itself is more than a decade old. Perhaps more useful now is the resources, the guidance that's issued by organisations like the OIA, and we'll be going on to talk about that later. I think you're going to address that particularly in part 2. And there are some other regulators which you might not expect to have a relevant remit in terms of disabilities and higher education, but I've just noted there the Competition and Markets Authority, the guidance it issued to the sector a few years ago, which makes it clear that treating students fairly and reasonably as an educational service provider does extend to those students with known vulnerabilities, and providing a supportive learning and pastoral environment, particularly through the provision of proper information and access to funding is a key part of that relationship.
And what would you say the key regulatory considerations are, and if there are any in particular OFS conditions of registration that perhaps are relevant?
Yeah, so on the next slide, we can see that the Office for Students does have a clear and direct remit to oversee these issues. And in fact, how registered providers support their disabled students is embedded within the registration regime created by the Higher Education and Research Act. So if we think about conditions of ongoing registration, the E-conditions of good governance include requirements around compliance with public interest principles. It includes a need to comply with equality and diversity legislation and of course with an institution's own policies. So that's a given. There's also an ongoing monitoring role for the OFS when it's dealing with access and participation plans. So all registered providers must have such documents in place, and these must contain particular commitments to increase numbers and improve outcomes for particular underrepresented groups, including students with disabilities. It's also worth mentioning the the Disabled Students Premium Fund that the OFS administers, which is currently around £40 million a year, that's distributed to sector institutions to help improve inclusivity. So yes, there is a clear sort of regulatory role for the OFS, and it does make its presence felt.
Okay, so we've briefly discussed the legal and regulatory side. Are you able just to explore a little bit further why the challenge is perhaps more acute for disabled students?
Yeah, so if we go to the next slide, I think the enhanced vulnerability of disabled students was captured well by the OIA in a recent annual report, which recognised that there are some challenges that all students will face during their time at university that can lead to complaints and disputes, so poor teaching, for example. And then there are those issues which will affect disabled students more acutely than their non-disabled counterparts, such as not being able to speak to the right people when needed, not having access to the right information. And in addition to that, there are issues which will only affect disabled students, problems with needs assessments or accessing specific disability funding. So what this means is that disabled students can be affected by all of these things in the worst situations. They have potentially deeper vulnerabilities, which is much more likely to result in significant negative outcomes, and that in turn is going to lead to more complaints, and that is what we do see in the sector, so it does make sense.
And would you say the pandemic's had a disproportionate negative impact for disabled students?
Yeah, so if we go to the next slide, I think it's pretty clear that the pandemic effectively confirmed what we already knew, which was that this enhanced vulnerability was always an issue for a number of different vulnerable student groups, not just disabled students, but there was definitely a disproportionately negative impact on those with disabilities. And a number of organisations have analysed the impact of the pandemic over the last couple of years and published reports that summarise its effects on different types of student. I'm thinking in particular of Policy Connect and the HE Commission, which published the quite well-known Arriving at Thriving report, which was focused on the experiences of hundreds of disabled students through that period of time. There's the Disabled Students Commission, the DSC, which is actually an initiative funded by the OFS. And it's published a number of reports, including the one I've shown there on the slide, which are aimed at informing and influencing HE policy and procedure. And then the third document I've listed is a report published by a student-led charity, Disabled Students UK, which I think is particularly useful because of the way it draws together the conclusions reached in other reports and provides consolidated findings. And if we go on to the next slide, we can see what some of those specific findings are. I mean, there's generally been an emphasis on the additional barriers that disabled students face. So thinking in particular of financial and bureaucratic hurdles, which directly impact on the amount of time that disabled students have to actually spend studying. There are still lots of disabled students who have other responsibilities, which again weigh down on their ability to access teaching and learning, and they may have health concerns which create additional difficulties as well. And what all of these organisations recognise is that there's a need to improve awareness and accessibility and to facilitate better social inclusion, and that information and device can help, particularly in the transition period, so getting into university as well as graduating once the course is completed. And unsurprisingly, the outcomes of these factors are pretty negative, often related to mental health problems, and do, as I've mentioned, have a disproportionately negative effect on disabled students. In terms of observations, generally there's still a concern about there being inadequate regulation in this area, such that there's still too much pressure on disabled students to address the inequalities they face themselves. So whilst they're trying to study, they're also trying to sort out whether they're getting what they're entitled to receive. And there's also ongoing concern about the speed with which problems are resolved, and that it shouldn't be the responsibility of students who are already suffering from a condition that's debilitating to have to work harder to get the support that they need. If we go on to the next slide, we can see some of the key recommendations that those reports have identified, which can be broadly divided into the 4 C's. So communication is clearly key, and information provision has always been an area that that regulators and commentators have sought improvement in. Making sure that there's the identification of and access to the correct members of staff and adequate consultation on any changes that will disproportionately affect disabled students. Certainty is another area which is crucial. Managing the expectations of students of any description is vital, particularly important for disabled students around modes of learning. Establishing key relationships like supervisors and mentors is particularly important, and avoiding late changes in approach that again will disproportionately affect disabled students' ability to continue with their studies. In terms of choice, this is really about building greater flexibility into teaching and learning and offering disabled students a choice of modes of study. So synchronous and asynchronous learning was something that has been proved to be possible during the course of the pandemic and has helped to maintain overall attendance by those students who perhaps don't have the same levels of mobility as they might. And engaging with students generally, extending deadlines, relaxing rules about the provision of evidence when seeking disability funding, for example, could all have an enormously positive impact. Perhaps the most important recommendations, they relate to consistency, and this is really about taking preventative measures, stopping the problems arising in the first place, which in turn should avoid the overuse of the formal complaints process by disabled students. So scaling up existing good practice and applying what will hopefully become sector-wide standards on issues such as automated captioning. So just improving that inclusivity benchmark so that everyone benefits and the number of disputes and claims is reduced.
And I know we've briefly touched on it, Kris, but what about funding? What's the position with that?
Funding. We couldn't possibly miss out funding. Well, the Disabled Students Allowance has been contentious for many years. It is non-means tested grant funding. It's designed to cover study-related costs for those students with particular needs, but that means it's reliant on external needs assessments to gauge and prove eligibility, which has always been an issue. And earlier this month, there was a publication of a review by Lord Holmes into the DSA and how well the system's working, and he's clear that it's still failing many disabled students, and made a series of recommendations, not just for providers, but also for the government and for the Student Loans Company and others. And he helpfully structured these around the student life cycle, so focusing on everything from the pre-application stage to post-graduation. So in terms of recommendations to government, this is really about making sure students understand what they're entitled to. So making the information in this area clearer, making the application process for funding easier to access, and hopefully make it take less time, because that in itself is problematic. And just generally working on improving the student experience and removing costs where it's not appropriate to charge them. So thinking particularly about the reasonable adjustments duty. In terms of those recommendations directed at providers, as you'd expect, they focus on the time that students are actually on their course, so the red boxes in the diagram. And there is apparently more that universities might do to support students in their application for DSA and in obtaining assessments to prove their eligibility. And of course, there's always the overarching role of each institution to ensure that its access and participation plan does accurately reflect what it actually does, so that the OFS can step in and make recommendations or revisit the commitments that institutions have made if that becomes necessary.
Okay, and just to finish this first part, Kris, what would you say the latest developments are, and are there any expected changes?
Yeah, so if we go on to the next slide, and again, well, we know that the OFS is looking at this area again. It will be introducing new conditions of registration from May this year. And thinking particularly about the so-called the B conditions, which focus on quality and standards. And there's one particular B condition that at first glance doesn't seem to be relevant, but because it concerns academic experience because it refers specifically to resources, support and engagement. Commentators do believe that that is a clear indication it is designed to cover disabled students and potentially other disadvantaged groups within the student population as well. It's about the promotion of inclusivity in terms of what resources are available, but also the way in which that they're provided and the way in which staff and students interact. So I think that will make a difference. And this is another acknowledgement of the importance of the student life cycle, in that it acknowledges the importance of success within and beyond higher education. So to that extent, it's consistent with the approach taken in the government's national disability strategy. And onto my final slide for this section, in terms of what we should look out for over the next few months or year or so. The OFS has very recently announced that it will also be publishing a report on the quality of blended learning later in the summer. This is a follow-up on the consultation that began last year and feeds into that quality and standards review that's led to those new B conditions I've just mentioned. I think we can expect the continued development of the mental health agenda in HE, particularly because of the high profile of student suicides and the pressure that's creating to look at this issue and to make changes to try and prevent that happening in future. There's also, I think, the prospect of more litigation in this area than there has been previously. I mean, one thing that makes any talk like this challenging for us as lawyers who specialise in student matters is that there's very little case law. If we were employment lawyers, we'd be spoilt for choice. But there's actually very little judicial comment, relatively speaking, on matters that specifically affect students. But there are signs of litigation at the moment, which may well develop the common law duty of care. It may well end the debates on the parameters of the duty of care that universities owe to their students, which have been ongoing for some time. Historically, those have been quite limited on the assumption that because most, if not all, students are adults, then there's very little that universities are actually expected to do, and it's actually organisations like the NHS who have to step in to provide all of the significant support. I suspect that is going to increasingly change, and it's possible that judges will now take the opportunity to provide the clarity that could be of assistance, unless they feel too daunted to actually make decisions that could have that level of impact across the sector as a whole. But if they do, I mean, it could have clear implications for the standard of care that universities are expected to adhere to, which in turn could impact on the risk of negligence claims. And it may also change the remit of the Equality Act obligations that institutions are deemed to owe to students, and in particular what is deemed to be reasonable in terms of the adjustments that they make. So that brings me to the end of part one. And if we go on to the next slide, Amber, I think we can say, so we're going to turn our attention now to the Office of the Independent Adjudicator. And there's a number of issues that we'd like to take you through. And Brad, alas for you, it's my turn to ask the questions, so I hope you're prepared. And I want to start with what can we learn from the OIA's recent analysis of complaints, particularly complaints relating to student disabilities, and any particular points that you think we should note?
So there's definitely some overarching points I think it'd be useful to outline. But before I do that, if that's okay, there's just two quick things I wanted to mention. Just to quickly respond to the comment which I've just seen. We do work on some worked examples via the OIA decisions and recent communications in part 2. So if we hopefully should cover some of that there and then respond a little bit further at the end. And secondly, just to say that this part is really to consolidate best practice and draw upon information and our experience of the recent approach from the OIA, with the aim to highlight some particular areas that may be pertinent to disability discrimination complaints. We're both very confident that you all have thorough and detailed student support and complaints policies, and this part is really aimed at drawing out some of the key points that we hope you find helpful. If we can move on to the next slide, please. So I'm hoping this works. I thought it would be interesting to channel my inner quiz show host and just do a quick poll to start this part. So you should have a pop-up box. And the question is, in 2019, what percentage of complaints reviewed by the OIA were identified as complaints from disabled students. A, less than 10%, B, between 10 and 15%, C, between 15 and 20%, and D, more than 20%. So that should stay for a couple of seconds, I think. So the majority going 56%, and D is the correct answer. So if we can go to the next slide, please. So as demonstrated, in 2019, over 20% of complaints raised by the OIA were either identified as complaints for disabled students. So the actual number is expected to be higher, as the figure doesn't really take into account students who may have chosen not to declare the disability. This 20% was a similar percentage in 2018, and the OIA have noted that disabled students are overrepresented in complaints. As a result of these percentages, the latest annual report references efforts made by the OIA to raise awareness and focus know-how on supporting disabled students. This is with the good practice framework for supporting disabled students sitting in the background, which was originally published in 2017. Whilst the OIA has noticed that complaint numbers are not indicative of wider institutional concerns, complaints generally have arisen where well-drafted procedures are not adapted to meet individual students' needs. The key question really, what does this mean for universities? Disability is a focus for the OIA. There are more complaints generally, with a trend towards non-physical disabilities, particularly mental health, and these complaints are more likely to be upheld. What's the risk? Where disabled students do not feel adequately supported, and the university can't evidence support provisions which are adapted to meet students' individual needs, complaints to the OIA are likely to increase and are likely to be upheld. The ultimate aim for all universities is to avoid complaints reaching the OIA stage in the first instance. And the first step, if you haven't done so already, post-pandemic, is to look at the university's policies and procedures in line with the updated guidance, know-how and regulations outlined in Part 1, with the aim to improve processes or look at any specific nuances that could be made to support students. It is inevitable that complaints will be raised. Students will often choose to contact the OIA, and whilst you can do your best to create the best policies and procedures, it's important that all complaints are responded to in an OIA-friendly manner.
Okay. Well, I'm just thinking of the cases we've worked on recently, most of which have involved consideration of the OIA's remit when asked to consider complaints that specifically involve alleged discrimination. So can you expand on that as a topic?
Yeah, of course. Next slide, please. So I think the starting point really is to consider the Maxwell case, which provides universities with clarification on the OIA's role. This is a 2011 case where a disabled student appealed against a decision to dismiss her judicial review application against the OIA. This started out as an internal complaint submitted to the university and was in relation to reasonable adjustments and failure to put in appropriate measures. The university accepted fault and offered to cover fees for a repeat year for the student. The student wasn't satisfied with this outcome and complained to the OIA asserting disability discrimination. The OIA considered the issues, but explained to the student that it was not a court and would not be able to make findings on discrimination. Having received this decision, the student was dissatisfied, believing it to be flawed and irrational, and argued that the OIA should have made a positive finding of disability discrimination against her. The appeal was eventually dismissed and provided the judge with the opportunity to clarify the OIA's role.
And in simple terms, presumably this confirmed that the OIA is not there to act like a court.
Yes, it did. Next slide, please. So the OIA's role is there to review a complaint and to see if a university decision was reasonable in the circumstances and justified, and if so, to what extent. If the OIA finds a decision was not reasonable, it'll then consider any recommendations that should be made. It's important to note that the OIA are not there as a rigorous adversarial judicial process, which covers areas such as proof of contested facts, application of legislation, and awarding of legal remedies such as declarations. The judge made an interesting comment which said, adjudication of whether discrimination has occurred requires the more stringent and structured procedures of civil litigation. Therefore, the student still has the opportunity to litigate in court and will often issue and stay proceedings pending the outcome of an OIA process. If a student chooses to go to the OIA and is then dissatisfied, they're able to resurrect county court proceedings.
Okay, and what sort of possible remedies are relevant when dealing with disability complaints in this context?
So next slide, please. So remedies can either be practical, financial, or a mix, some of which are outlined on the slide. Really, there's 4 key points I wanted to flag regarding remedies and DD claims. Firstly, the OIA's putting things right guidance references financial payments where it is only fair and reasonable to do so, and compensation will not be provided for speculative financial loss or lost opportunities. In these types of cases, students will often request compensation on the basis they haven't gone into employment as expected, and it's important to remember the limits in the guidance. Secondly, where compensation is advised, a cautious approach needs to be adopted if the university is offering to offset any outstanding fees with the compensations being paid, but this may not be seen as adopting a reasonable approach. Thirdly, where a student instructs lawyers and subject to the university's policies not being excessively complex, an award for payment of the student's legal fees will not normally be made. And lastly, whilst there is a focus on practical remedies, there's likely to be a distress and inconvenience element to disability-related complaints, and therefore financial compensation may be awarded in line with the moderate to severe bands which is set out in the OIA's putting things right guidance.
So, I mean, it's well known that the OIA publishes details about a number of its complaints decisions each year, and some of them are public interest decisions, so that they actually name the institutions involved. Is there anything we can learn from these?
Yes, so next slide, please. This is probably best approached in two parts with some health warnings. So firstly, there's likely to be a change in the position adopted by the OIA in future decisions. And secondly, it's important to remember that these decisions were reached on their individual circumstances. However, we are able to decipher some trends and themes that we hope are useful. So firstly, looking at OIA decisions that were not justified and where the approach of the university was considered reasonable. So firstly, a student and they must be progressing complaints. On this particular decision, a disabled student had 10 days within the policy to escalate his grievances to stage 2. The student waited 2 years and this was deemed out of time by the university. The OIA agreed with the approach taken. Secondly, the student must seek diagnosis and provide evidence. On this particular decision, no explanation was provided by the student in raising an impaired performance claim for the previous academic year, which was ultimately dismissed by the university. The OIA agreed with the approach and said that providers have a duty of fairness to all students and to uphold academic integrity. Lastly, students must seek support. On one particular decision, a student failed 2 modules and was withdrawn from the course. The student later undertook a test which suggested he was dyslexic. The student didn't raise any concerns until after he was withdrawn, and the student appealed this decision, and this was rejected by the university. The OIA upheld the approach and noted that students have responsibility to seek support if they are concerned. Next slide, please. As I said, there is a health warning to these decisions, and I don't think no presentation at the minute is complete without the COVID reference. I think it's fair to say that COVID has changed the landscape, and for advising clients, we have seen a shift in OIA comms and recommendations where universities are almost held to a higher standard. There is a need to filter these decisions through the pandemic lens. Adopting a pre-pandemic approach is not seen as acceptable, and universities need to ensure that they are being proactive, particularly to students who may be seen as vulnerable or at a disadvantage. This will be critical in disability-related complaints, and we do anticipate the universities will remain to be tested and will continue to be held at a much higher standard. Next slide, please. So moving on to some justified OIA public interest decisions, which really confirm the importance of getting things right and what are expected of universities. We've been able to distill these down into four key trends. Firstly, funding. So in one particular decision, a disabled student with complex needs sought additional adjustments beyond the scope of the funding available. The university told the student that he needed to exhaust the DSA funding first, then apply for mean tested support. The OIA disagreed with this approach and said the university should have explored alternative options for making reasonable adjustments and should not have required the student to complete complex paperwork. Secondly, competence standards. In one particular decision, a disabled student sought additional reasonable adjustments due to an injury which was unrelated to disability. The student was told this was not possible to replace, as they could not replace exams, as academic standards could not be secured, and suggested a larger number of shorter exams. The student appealed this decision, which was rejected. The OIA disagreed with the approach and found evidence that the school had replaced exams with essays in the past and could have done so in this instance. Next slide, please. Thirdly, non-attendance. In one particular decision, a disabled international student was withdrawn from a course for non-attendance. The student complained that his disability was not properly considered, and the student did not submit evidence of this disability until around the end of the disciplinary process. This evidence was not really considered by the university. The OIA disagreed with this approach and said the university should have considered its regulations and procedures once it had the evidence to justify what reasonable adjustments might be implemented, and there's no evidence it did this. Lastly, document the process. In one decision, a disabled student had made an application for mitigating circumstances, which was rejected after the student forgot to take IT equipment on an overseas trip. The crux of this decision really was that the university review process was poorly documented, was missing key information, and made it impossible to tell if the student's conditions and circumstances were properly considered.
Thanks, Brad. And can you possibly distill this down into some more practical terms?
Yeah, so we've helpfully got a 5-stage approach outlined by the OIA. If we can go to the next slide, please. This was a pre-COVID public interest decision, and I'll just quickly run through the 5 points. So this is, number 1, is the student disabled? Number 2, if so, what provisions are we now applying to them? Number 3, do these provisions place the student at a substantial disadvantage? Number 4, what could be done to prevent that disadvantage? Number 5, would it be reasonable to take those steps? Now, this decision provides a real helpful structure for universities to adopt when considering the support measures for students who may be suffering with a disability. It also remains sensible to document or note your thinking around these 5 steps so you can evidence the considerations that have been taken.
And are there any best practice points it would be useful to mention just to finish up part 2?
Yes, so if we move on to the next slide, please. I think the 3 main key takeaway points from part 2 will be firstly to manage student support and the local stage complaints procedure with the OIA framework and guidance in mind. Whilst there'll always be students that wish to complain, the ability to back up and cross-refer communications and decisions reached with a framework and guidance in mind will definitely put you a step ahead if you need to manage the process moving forward. Secondly, clearly and accurately document every consideration and decision taken. The comprehensive notes from the infancy of providing support will become crucial should a student complaints be escalated to the OIA or court. And lastly, prepare for the worst and look at the bigger picture. Subject to limitation periods, a civil claim against university remains open. I think it's very easy to become entrenched in the detail of a complaint at a local stage. However, when you do get an opportunity, we really recommend that you take a step back and ask yourself, how could we justify our actions and approach in a court should the student choose to bring a claim? And can we be confident the approach adopted and decision reached what can we think? Sorry, let me reverse. The second point would be, can we be confident if the approach adopted and the decision reached, if they were challenged legally? Thank you very much for listening this afternoon. I know the after lunch slot is quite tricky, so we hope it's been useful for you. I'll now hand over to Kris to the last slide.
Okay, so the final slide, a quick summary. I think it's clear that the complex challenges posed to HE providers by disabilities remains as important as ever. Perhaps it's more dynamic than it used to be as well. The pandemic clearly created some significant challenges, but it also showed what was possible in terms of technologically driven inclusivity measures. And there are lots of changes that can now be implemented. But in turn, it's clear that regulators are also modifying their approach and their expectations in terms of what providers are now expected to deliver in this post-pandemic era. And it's important that we do keep track of litigation over the next few months and years to see how the parameters of the duty of care, how the parameters of the requirements of the Equality Act might now shift. So that brings us to the end of the formal part of the talk, and I suppose we can look now to the chat box and see if there are any particular questions. Yes, so we've got a couple of issues that come up from time to time. What is the most common complaint from disabled students, and what's the biggest claim, and for what? I think what used to be the most common complaint in this field, I think, was just access to concessions during the course itself. So it probably focused around access to lecture resources and perhaps assessments. I think what's interesting recently is that there's been a shift towards all of the stages of the student life cycle. So not just during the sort of core delivery of the course itself. We've seen complaints about the provision of information before a course has even started from disabled students who I think recognise that they are entitled to clearer information sooner, and that they need to be put in a position where they can make fully informed decisions about where they're going to study and what sort of support they're going to be accessed when they get there. So I think whereas historically the common complaints were around assessment and exam concessions, I think that started to shift, and there's a broader spread of issues that are being raised. What's the biggest claim and for what? I'm not sure I have a direct answer to that. I don't know if you do, Brad. I mean, I know that that we did do some research when working on a disability case recently, which actually involved the OIA trying to negotiate a settlement with the provider so that it could reach an end without county court litigation. And I think the award that they had in mind in that case was, and this was a complaint that wasn't purely about disability issues, but that was an exacerbating factor. But it was about £35,000 because it had been going on for a number of years, and therefore the quantification of loss could be extrapolated over that sort of period of time. So that's the sort of numbers we're talking about. We've also seen evidence of students being aware of the value of distress and using the Vento bands that Brad touched upon in his talk, the bands for distress, to quantify a claim, which broadly can be up to about £25,000 or £30,000 in extreme cases. So I think those are the sorts of numbers we're looking at. On another question here about who defines what a reasonable adjustment is. What if one student needs an adjustment that may cost £100,000? Who's to say this is or is not reasonable? Again, that's an issue that comes up fairly frequently, and the answer, as ever in these cases, is that reasonableness is context dependent, and also, as ever, the case law that we need to rely on to inform our approach to this is employment-based. And there have been cases recently where consideration's been given to whether a given respondent has the resources to provide whatever significant adjustment that the claimant expected. And there is a checklist of factors that an institution or respondent generally is expected to go through to determine whether something's reasonable. So cost is one. Cost is always a factor that's relevant, and it will, of course, matter what sort of resources the institution has available to it, but also what level of resource it has applied to that sort of adjustment in the past. So there's a level of sort of precedent there as well. And there are other factors like, to what extent would making the adjustment sought have the effect desired? So there are a lot of contextual issues that an institution would be expected to work through before it makes a decision on whether to provide the adjustment. But say cost is a relevant consideration, will often drive those analyses. Now, as a tutor, do I have to recognise and assess students for dyslexia, or do they have to provide me with medical evidence to support them? It's difficult. I think we touched upon in the talk the way that the pandemic has challenged some assumptions about assessment. One of the big sticking points for getting support and funding is, of course, having the evidence to prove entitlement. And because of the difficulty of doing that during the pandemic, there were many calls for greater flexibility, not requiring students to produce evidence, applying blanket no detriment policies to all students so that it didn't matter whether you could actually evidence a need. Here, I think we're talking about dyslexia, and whether as a tutor you have to recognise and assess it. I'm not sure that that is technically feasible. So I'm not convinced that you do have the opportunity to take that approach, given that there is a technical process to follow and there are assessments that need to be completed. So I still think it's the case that they have to provide medical evidence of a particular condition. I think the issue is, do we know whether or not they can actually provide the evidence that you would ordinarily expect? And if not, is there another less formal way of assessing that they have a level of need, and what sort of adjustments could be made to reflect that? The challenge then is, of course, not undermining academic integrity and academic standards, and not compromising competence standards, because the Equality Act doesn't require you to do that. So yeah, a difficult one to answer, but I suppose broadly speaking, I don't think you do have to recognise or assess students for that type of condition, but you might have to think a little bit more carefully about whether you need the level of evidence that in a pre-pandemic world you would have expected. I'm not sure if we've got...
I suppose just to say as well, our contact details are on the slide, so if anybody does think of some questions once this is finished, then feel free to email or give us a ring.
And we've had one last question. We just finish up with this one. If I had to increase test times for disabled students, do I have to increase it for all, including non-disabled students? I mean, I think there have been cases where the length of time students are given to complete assessments is a genuine competence standard. So if that's the case, and there was a decision that that was included in the list where working under pressure is actually what's being assessed, as well as the content of the academic programme. So in those cases, there is no requirement to increase the amount of time that students are given. If there are cases where it is not a competence standard, do you have to increase it for all students, including non-disabled students? I think that sort of undermines the basis for applying a time limit in the first place. So if it's not a competence standard, then yes, you should adjust it for disabled students that have an entitlement to that adjustment. I don't think that means you have to increase it for all students. But that's not what the Act would require.